Hello viewers, Namaskar. I am Professor Vageshwari Deswal, a professor at Faculty of Law, University of Delhi. We are doing a series on new criminal laws. Today, we will be discussing a very important topic, and that is preliminary inquiry. So viewers, there has been a lot of debate about the issue of registration of first information report. While the law obligates police officers to register FIRs in cases where the information supplied discloses the commission of a cognizable offence, there have been instances where police refuse to register the FIR, or sometimes they unnecessarily delay the registration of FIRs and they take the pretext that we have to first conduct a preliminary inquiry. So the question arises, what is preliminary inquiry? Is registration of first information report mandatory in all cognizable cases, or does the police have some discretion or latitude in registration of FIRs? So in this lecture, we will try to decode these questions, and we will also discuss the concept of preliminary inquiry. Preliminary inquiry has been provided for specifically under section 173 subsection 3 of the BNSS. So the BNSS, which is the Bharatiya Nagarik Suraksha Sanhita, it establishes a strong framework for the conduct of preliminary inquiries, thereby ensuring that investigations are initiated with diligence, transparency, and there is respect for the rights of all the parties that are involved. So let us understand what is preliminary inquiry. It is an initial investigation to ascertain whether there exists a prima facie case for offences punishable for 3 years or more, but less than 7 years of imprisonment for proceeding with a full investigation. So first thing that is very clear by this is that, see, unless and until we are dealing with the offence which is punishable with minimum 3 years and the punishment can go up to 7 years. So between 3 to 7 years. Here we are not dealing with offences for which punishment is less than 3 years or more than 7 years. In those cases, we do not have any provision of preliminary inquiry provided under the BNSS. So this is something which has been specifically introduced in the statute by virtue of BNSS only in cases, here we are specifically talking about cognizable offences, and that too where offences are punishable between 3 to 7 years of imprisonment. See, under the old CRPC, the scope of preliminary inquiry was only to ascertain whether any cognizable offence is committed or otherwise, and if cognizable offence appears to have been committed, then police officer had no discretion. He was supposed to immediately register the case, first information report, under the relevant sections of law, and thereafter to proceed to investigate the case as the law provides. Section 159 of the old CRPC, it gave discretion to conduct an investigation or a preliminary inquiry to the magistrate. After a report is submitted to the magistrate under section 157 of the code, he may order an investigation, or if he thinks fit, he may direct a magistrate subordinate to him to hold a preliminary inquiry. However, it is important to note that this discretion which is available to the magistrate, that is also available only after the registration of FIR. That is, first the FIR has to be registered. In Lalita Kumari versus Government of UP case, this is a landmark case, the Supreme Court had noted that in certain situations, when the information obtained does not reveal the commission of a cognizable violation, but it suggests the need for an investigation, then a preliminary inquiry may be carried out simply to determine whether any cognizable offence has been committed or not. So, you see here we are not going into the merits or demerits of the case, we are not conducting full-fledged investigations. This is to be allowed only to ascertain that whether an offence which is of cognizable nature that has been committed in the first place or not. Then the court had further ruled in Lalita Kumari's case only that an inquiry resulting in the disclosure of a cognizable offence should be followed by registration of FIR, and any inquiry resulting in the closure of a complaint should be supplied, along with a copy of entry disclosing the reasons in brief for the closure of complaint to the complainant immediately. See, this is also to be done maximum within a period of 1 week, not beyond that. The court had clarified that the purpose of an inquiry is merely to ascertain whether any cognizable offence has been committed or not, and this is not to check the veracity of the information. So, we are not going at this stage into the truthfulness or whether the information is truly genuine or not. Here we are just supposed to ascertain that whether a cognizable offence has been committed or not. If the answer is yes, then FIR has to be registered and investigation has to be carried out. Now, under the Bharatiya Nagarik Suraksha Sanhita, there is a provision for preliminary inquiry, specific provision for that. So, in that sense, this provision for preliminary inquiry within the Bharatiya Nagarik Suraksha Sanhita, it marks a progression from the previous legal guidelines, including the landmark Lalita Kumari judgment, by broadening the scope and stipulating detailed procedures for preliminary inquiries. It further mandates that such inquiries have to be completed within a period of 14 days, and this is to be done with the requirement of prior permission from a Deputy Superintendent of Police. So, this has enhanced the monitoring and accountability. See viewers, while the Lalita Kumari judgment mandated that FIRs must be registered if the information discloses a cognizable offence, and it allowed preliminary inquiries only to determine if a cognizable offence was revealed, the BNS has gone a step further and it has further expanded the scope. Lalita Kumari guidelines, they had clearly specified categories such as matrimonial disputes, corruption cases, commercial offences, cases with abnormal delay in reporting of cases without any justifiable explanation, and cases involving medical negligence as cases under which preliminary inquiry was permitted. So, you see there were these specifically mentioned 5 categories under which there was some sort of a discretion or latitude which the investigating officer could exercise, and he could conduct a preliminary inquiry, but only under those 5 specified categories. What are those categories? See, medical negligence cases, matrimonial disputes, corruption cases, commercial offences, and then there was one broad category, that is those cases where there was an abnormal delay in registering of FIR, and that too was without any justifiable explanation. See, in case there is a delay in registration of FIR and the informant has some sort of a justification, then we could directly register the FIR. But if there was no justifiable reason why the information was given at such a late date, then in such cases the police officers could exercise some sort of a discretion and conduct a preliminary inquiry. Now, Bharatiya Nagarik Suraksha Sanhita, which is the new law, it applies broadly to all relevant offences within the defined punishment range. And what is the range? 3 to 7 years. So, you see, it is not restricted only to those 5 categories which were mentioned in the Lalita Kumari guidelines. Now, this provision for preliminary inquiry, it has been considerably broadened. So, all offences that carry a punishment which is more than 3 years and less than 7 years. So, in those cases, a preliminary inquiry can be conducted. So, now under the Bharatiya Nagarik Suraksha Sanhita, preliminary inquiries are conducted to ascertain if there is a prima facie case for offences punishable with 3 years or more, but less than 7 years of imprisonment. So, this also introduces a specific timeline. And what is the timeline? 14-day period. It has been fixed that you have to necessarily complete the preliminary inquiry within a period of 14 days. Why has this specific time period or the specific timeline been introduced? So that unnecessarily, in the garb of conducting a preliminary inquiry, investigation is not delayed beyond the period of 14 years. Furthermore, moving beyond Lalita Kumari judgment, Bharatiya Nagarik Suraksha Sanhita, it requires a prior permission from an officer who is not below the rank of Deputy Superintendent of Police. This ensures a greater oversight and accountability. See, this was not provided under the Lalita Kumari judgment. Now, under BNSS, the Deputy Superintendent of Police has to necessarily grant permission for conducting a preliminary inquiry. So, it is not that the police officers, they have an unlimited discretion to decide whether they have to register the FIR or whether they have to first conduct a preliminary inquiry. Now, let us talk about the procedure that has to be followed while conducting a preliminary inquiry. The first step is approval for inquiry. So, the requirement now is to obtain prior permission from an officer. And which officer? He should be an officer who is not below the rank of Deputy Superintendent of Police. And then they have to also evaluate the nature and gravity of the offence to determine the necessity of a preliminary inquiry. See, just because there is an offence which falls in the category of 3 to 7 years of punishment, that does not necessarily mean that a preliminary inquiry has to be mandatorily conducted. See, depending upon the nature and gravity of the offence, the police officer has to see whether there is a necessity of a preliminary inquiry, and then he has to specify that requirement to a senior police officer, one who is not below the rank of DSP, who will further endorse that yes, you can conduct a preliminary inquiry, and then only after getting the approval can they proceed with conducting the preliminary inquiry. After getting the approval, the next step is conducting the inquiry. So, now the officer in charge of the police station is duty bound to conduct and conclude the preliminary inquiry within 14 days to ascertain if there is a prima facie case. See, once you get the permission, you cannot just delay it anymore. Immediately start conducting the inquiry. You have to document all findings, you have to record all the evidence that is gathered during the inquiry, conduct the preliminary inquiry diligently within minimum time period, and the maximum time period is 14 days. And what is the objective of conducting the preliminary inquiry here is to only ascertain whether a prima facie case exists or not. After the preliminary inquiry has been conducted, the documents have been collected, or all the evidences they have been documented. Now, after concluding the inquiry, if he finds out that a prima facie case exists, then he should proceed with the full investigation immediately. But if no prima facie case is found, then he shall document the findings and he shall close the inquiry. If he closes the inquiry, he has to send a report to the approval authority. See, he took the approval from a Deputy Superintendent of Police to conduct the preliminary inquiry. Now, after conducting the inquiry, if he feels that, see, a prima facie case is not being made out, then he will close the inquiry. But also inform the approval authority that you had given me this permission to conduct preliminary inquiry, I conducted it diligently, but there is no prima facie case. At the same time, he should also communicate the findings of inquiry to the complainant. See, it is the complainant who is interested in registration of FIR. So, if the prima facie case is not disclosed after conducting the preliminary inquiry, there is also a responsibility on this officer to also communicate the findings to the complainant that, see, we did not find sufficient material to conduct a full-fledged investigation. Sometimes what happens, the preliminary inquiry clarifies that a case is not being made out. Now, what is to be done? The apex court in Lalita Kumari judgment had directed that in cases where preliminary inquiry ends in closing the complaint, a copy of the entry of such closure must be supplied to the first informant forthwith, that is as early as possible, and it should not be done later than 1 week. So, as early as possible, we have to supply a copy of the closure report to the informant also, and the report must also disclose reasons in brief why the complaint had to be closed, why we could not proceed further, what made us come to the conclusion that a prima facie case is not being made out. Then there is another important aspect of preliminary inquiry, and that is reporting and documentation. See, the police officer who conducts such preliminary inquiry is required to maintain records. He has to ensure that all steps taken during the preliminary inquiry are thoroughly documented, and he is also required to keep records of all permissions, all findings and all decisions whatever he might have taken related to the inquiry. So, reporting, documentation, these are important aspects of preliminary inquiry. And then the next step is regular reporting. So, the police officer who is conducting preliminary inquiry shall submit regular reports to the supervisory officers on the status of preliminary inquiries. It is not that once he gets permissions, he sets off to conduct a preliminary inquiry and then he comes back after 14 days. No. When he is in the process of conducting the preliminary inquiry, he is supposed to regularly report to the supervisory officers that what is the status of the preliminary inquiries, and he is also required to update the relevant records and databases with information from the inquiry. Now here, once we are talking about the responsibility of the police officer who is conducting the preliminary inquiry, let us also talk about the responsibility of the officer in charge of the police station. See, the police officer shall maintain a register of preliminary inquiries in the format that is prescribed by the Director General of Police. He shall record the gist of information in the general diary and the details in the preliminary inquiry register pro forma, of which will be prescribed by the Director General of Police. So, there has to be a duly prescribed pro forma in which all the details relating to preliminary inquiry, they have to be maintained. He is also supposed to obtain permission in writing from the jurisdictional Deputy Superintendent of Police to conduct a preliminary inquiry, recording the reasons why a preliminary inquiry needs to be completed. Then, if the preliminary inquiry is not completed within 14 days, he is to immediately proceed with FIR registration. Okay. So, either you complete the preliminary inquiry because it is a specified timeline, it is a time bound procedure, you have to mandatorily complete it within 14 days. If you are not able to do so, then you have to register the FIR, you cannot delay the process of investigation anymore. If it is not completed within 14 days, register the FIR and then start investigations. Then it is also the responsibility of the officer in charge of police station to ensure compliance with all the SOPs, that are the standard operating procedures laid down by BPRD during the registration and inquiry process, and he should also provide necessary support and resources for the effective implementation of the standard operating procedures. After this, we come to now the responsibility of the Deputy Superintendent of Police. Now, he is also responsible here. He will have to maintain a register of preliminary inquiries, and what should be the format? The format shall be prescribed by the DGP. See, in every state the DGP shall prescribe a format, how they have to maintain a record, a register of all the preliminary inquiries that they have conducted. And what are the responsibilities further of the Deputy Superintendent of Police? Once an application comes to him, in which he is supposed to give permission for conducting a preliminary inquiry, or if required he can deny the same also. So, where he feels that it is a fit case for conducting preliminary inquiry, then the DSP shall grant permissions in writing within 24 hours of receiving the request from the officer in charge. So, you see, there is a specific timeline for everything. The DSP also cannot delay the process of granting request for more than 24 hours. If he feels that permission has to be granted, he has to promptly act on the request, and he has to grant the request, grant the permission, and that too in writing within a period of 24 hours of receiving the request. If he denies the permission, or where permission is not granted, or where decision is not duly communicated by the approving authority within the time frame, then what is the officer in charge supposed to do? He will proceed with the registration of FIR after waiting for 24 hours. He will register the FIR and he will start investigations. If the preliminary inquiry is not completed within 14 days, then what will the DSP do? He will show cause the inquiry officer. See, he had granted permission with utter promptness within 14 hours, within 24 hours for conducting the preliminary inquiry, and thereafter the police officer is supposed to conclude the preliminary inquiry within 14 days. But where the police officer fails to do so, then the DSP will show cause the inquiry officer. In reply of this show cause, the police officer give a reply, and if the reply is not satisfactory, if the DSP feels that the justification that he has sought is not up to the mark, then in such cases the DSP can initiate departmental action against such a police officer. Now, what is the role of the Superintendent of Police? See, we have talked about, when we talk in the context of preliminary inquiry, we talk about the responsibility of the investigating officer, of the officer in charge of police station, also the responsibility of the Deputy Superintendent of Police who is supposed to grant permission, the DGP who is supposed to supply the format, how preliminary inquiry records are to be maintained. Now, what is the role of the Superintendent of Police? He is also required to review preliminary inquiries conducted in his jurisdiction during the monthly crime review meeting, and if he feels that whatever is happening in his jurisdiction needs some sort of an improvement, then he is supposed to take corrective measures wherever required. See, viewers, it is important to note here that certain sections mentioned in section 199 subsection C of the Bharatiya Nyaya Sanhita fall under the punishable range that are mentioned under section 173 subsection 3 of the Bharatiya Nagarik Suraksha Sanhita. Now, what are those offences? Of those 3 years or more but less than 7 years, still option for preliminary inquiry has been ruled out expressly by the law itself and is not available for those offences that have been mentioned in section 199C. So, you see, although on one hand section 173 subsection 3 of the BNSS says that wherever there is an offence that carries a punishment of more than 3 years, less than 7 years, then preliminary inquiry may be done, but then at the same time we have a corresponding provision under the Bharatiya Nyaya Sanhita section 199 clause C, which rules out preliminary inquiry cannot be conducted in the offences that have been specifically mentioned in those sections, even though the punishment that those crimes they carry falls within this permissible range as provided under 173(3), that is 3 to 7 years. According to section 199C of the Bharatiya Nyaya Sanhita, any officer who fails to record any information given to him under subsection 1 of section 173 of BNSS in relation to cognizable offence that are punishable under section 64, 65, 70, 71, 66, 67, 68, 74, 76, 77, 79, 124, 143 or 144 shall be punished with rigorous imprisonment for a term which shall not be less than 6 months, but which may extend to 2 years and shall also be liable to fine. So, you see, in cases of rape, molestation, disrobing, voyeurism, eve teasing, acid attack and trafficking, there is no discretion with the police officers to conduct a preliminary inquiry. They have to mandatorily register an FIR. Similarly, when we are dealing with cases covered under the provisions of the SC/ST Prevention of Atrocities Act 1989, they cannot be legally covered by this provision. Therefore, FIR in such offences should be registered without any preliminary inquiry whatsoever. Now, before we conclude, let us talk about benefits of preliminary inquiry over mandatory registration. The possibility of misuse of power against an individual who might be falsely implicated in an FIR cannot be ignored. See, not every FIR is based on gospel truth. What about false accusations? Therefore, it is important to note the concerns associated with mandatory registration of FIR and understand that preliminary inquiry can help in segregating actual crimes from fake cases. There was this leading judgment of Supreme Court 1978 case, this is Motiram versus State of MP, in which Justice Krishna Iyer had said that there are grave consequences of pre-trial detention. He observed that psychological and physical deprivation that comes along with being in jail, even though he is presumed to be innocent, is worse than that of a convicted accused. See, sometimes an accused loses his job if he has won, sometimes he is prevented from contributing to preparing his defense. Moreover, the burden of detention, it frequently falls heavily on the innocent members of the family. Then coming to the stigma that is associated with being accused of a crime. Then one who is facing criminal offences, they are not, trial in criminal offences are not considered suitable for government appointments. So, in order to be considered eligible, a person should have either no charges pending against them or should have been acquitted of those charges. Moreover, the law says that acquittal must not be out of a compromise between the accused and victim or due to witnesses turning hostile. Under section 6(2) of the Passports Act also, the passport authority can refuse a foreign visa to an applicant if in the preceding 5 years they have been convicted of an offence of moral turpitude and have been sentenced to more than 2 years imprisonment, or even where criminal proceedings are pending against them. So, you see how fake complaints can play havoc with the person who is wrongfully accused of a crime. But at the same time, when we are talking about the necessity of conducting preliminary inquiries, we have to ensure that registration of FIRs in genuine cases should not be a tedious or cumbersome exercise for the informant. Thus, a time-bound preliminary inquiry in accordance with SOPs laid by BPRD provides the best balance between mandatory registration of FIRs and conducting of preliminary inquiries to ascertain the veracity of a complaint, whether a prima facie case exists or not. So, viewers, that will be all for this session. Thank you.